When Facebook embraced the Metaverse by rebranding its corporate name to Meta in October 2021, it did much more than acknowledge its own place in this emerging experience for social and business communities. It also opened the door to other companies and individuals interested in jumping on the bandwagon, including, of course, cybersquatters, who are nothing if not opportunistic. Since Facebook's announcement of its name change, a number of cybersquatters have registered domain names that contain the words Meta or Metaverse, and at least 2 have already resulted in decisions in favor of trademark owners who filed complaints under the UDRP, the Uniform Domain Name Dispute Resolution Policy. Now, Facebook did not create the Metaverse, and it doesn't own the Metaverse or even any trademark registrations for the word Metaverse, at least not in the United States, where Facebook's headquarters is located. Interestingly, though, a number of other companies do own trademark registrations that consist of or include the word Metaverse, the oldest of which in the US appears to be Steve Jackson Games, which obtained a registration all the way back in 1997 for use of the word Metaverse in connection with computerized entertainment and education services. The Metaverse has come a long way since then, and today it describes what Mark Zuckerberg has called the successor to the mobile internet, a set of interconnected digital spaces that let you do things you can't do in the physical world. In announcing Facebook's name change to Meta, Zuckerberg said,
"The next platform and medium will be even more immersive, an embodied internet where you're in the experience, not just looking at it. And we call this the Metaverse. And you're going to be able to do almost anything you can imagine. Get together with friends and family, work, learn, play, shop, create, as well as entirely new categories that don't really fit how we think about computers or phones today."
Now, I'll admit that I'm not sure I fully grasp this concept, but it's clear that the Metaverse is emerging as something that's at least trendy, if not truly important. And when any new concept arises, cybersquatters are ready to take advantage of it just as well as anyone else. Which leads me to talk about the first 2 UDRP decisions involving the Metaverse, DisneyMetaverse.com and TencentMetaverse.com. Interestingly, both of these domain names were registered by the same person on the same date, even though they target different trademark owners. So the first case, DisneyMetaverse.com, was filed, as you can easily guess, by Disney Enterprises, which owns the well-known Disney trademark, which has been registered for use in connection with children's entertainment goods and services since at least 1981. In the spring of 2021, the chairman of Disney Parks, Josh D'Amaro, began talking about how Disney would embrace the Metaverse. As a Wall Street Journal article described it at the time, the 50-year-old executive, whose division earlier this year closed dozens of Disney stores to encourage online shopping, wants to turn the company's parks into a metaverse, where such fluidity between the physical park and digital world is encouraged. And in an interview with CNN, D'Amaro said the Metaverse provides us with unending opportunities at these theme parks that can create a very forward-looking digital footprint with our legacy assets. Well, just one day after these interviews were published, an enterprising cybersquatter registered the domain name DisneyMetaverse.com. Now, before I talk about what happened in the UDRP case, let me just pause for a moment to emphasize an important lesson here for companies of all sizes. Before announcing a new product or service, or even, as in this case, a concept, consider registering the obvious domain names. If Disney had proactively registered DisneyMetaverse.com before talking about its vision for the Metaverse, perhaps it could have prevented this domain name dispute from arising in the first place. In any event, according to the UDRP decision in this case, the registrant of DisneyMetaverse.com tried to sell the domain name, which apparently prompted Disney to file its complaint at the forum in November 2021, which was shortly after Zuckerberg announced Facebook's name change, and the word and concept of the Metaverse began to attract a lot more attention. Not surprisingly, this dispute turned out to be an easy win for Disney in a decision issued in December 2021, with the UDRP panel interestingly referring to the word Metaverse as a generic term that, combined with the Disney trademark, resulted in a domain name that was confusingly similar to the Disney trademark. And on the element of bad faith under the UDRP, here's what the panel wrote. The panel infers that respondent registered the disputed domain name with actual knowledge of rights and complainant's mark at the time of registering the disputed domain name due to the notoriety of complainant's mark, and the fact that respondent registered the disputed domain name comprising of Disney and Metaverse after the announcement of complainant's well-publicized and new Metaverse experience. The panel then added, complainant contends that bad faith is evidenced by respondent's attempts to sell the disputed domain name. Use of a domain name to offer a domain name for sale may be evidence of bad faith per policy paragraph 4B1. And as a result, the panel ordered the domain name transferred to Disney. Now, the other Metaverse UDRP decision for the domain name tencentmetaverse.com was issued in January 2022 by WIPO and is in many ways similar to the Disney case, which is not surprising since, as I mentioned earlier, the same person registered both domain names on the same date in April 2021. But unlike Disney, Tencent, which is a large Chinese company behind a number of popular online games and communication products, apparently didn't start talking about its vision for the metaverse until 7 months later, when the Tencent CEO said, anything that makes the virtual world more real and the real world more rich with virtual experiences can become part of the metaverse. Now, Tencent filed its UDRP complaint shortly before this, and the domain in this UDRP case, like the domain name in the Disney case, was, according to this decision, also being offered for sale. And just like the Disney Metaverse.com decision, the Tencent Metaverse.com decision was short and straightforward, with the panel finding that because the Tencent trademark was recognizable within the disputed domain name, the addition of the word metaverse did not prevent a finding of confusing similarity. And on the UDRP's bad faith element, the panel reached a similar conclusion, writing the following. Given the reputation of the complainants and the Tencent trademark, the panel agrees with the contention of the complainants that it is inconceivable that the respondent registered the disputed domain name without knowledge of the Tencent trademark at the time of the registration, as a simple internet search would have revealed the complainants and the famous Tencent trademark. The complainants have also provided evidence that the disputed domain name was resolved to a parking website offering it for sale. This indicates that the respondent's intent in registering or acquiring the disputed domain name was to profit in some fashion from or otherwise exploit the complainant's trademark. And as a result, the panel ordered the domain name transferred to Tencent. Now, in addition to the Tencent and Disney cases, there are a number of other UDRP cases that are pending as I record this video in January 2022, including one for the domain name metaversecalvinklein.com, which contains the well-known fashion trademark, and another UDRP dispute was recently withdrawn for the domain name metaversemorganstanley.com, which appears to have been settled since the domain name is now registered to Morgan Stanley, the financial services firm. So, what lessons do these cases hold for trademark owners? I think there are at least three important takeaways. First, as I said earlier, trademark owners should be proactive and consider registering domain names that contain the words meta or metaverse plus their trademarks to potentially avoid some domain name disputes in the first place. But of course, it's impossible to register every potential combination, so it's impossible to prevent all instances of cybersquatting. Second, it's clear that despite a number of pending trademark applications that include the word metaverse and even some registrations, like the one I mentioned that's owned by Steve Jackson Games, inclusion of the word metaverse in a domain name does nothing to prevent a finding of confusing similarity under the UDRP. In other videos, I've talked about the interesting issue that arises when a domain name dispute involves multiple trademarks owned by two or more entities, but so far at least, that has not caused any problems for trademark owners in metaverse UDRP cases. And finally, a third lesson for trademark owners here is that the UDRP is a very important and helpful brand protection tool for metaverse-related domain names, which is not surprising given how important the UDRP has been for trademark owners for more than 2 decades. While the metaverse seems to have suddenly become a hot concept, the UDRP is a tried and true brand protection mechanism that helps trademark owners protect themselves in this exciting frontier. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.